This courtroom hearing starts like a routine traffic case, but within minutes, it turns into pure chaos. Mr. Johnson is facing 2 charges, speeding 82 in a 65, and driving without proof of insurance, a misdemeanor that can actually carry jail time and a mandatory fine. Simple case, right? Not even close. Instead of entering a plea, Mr. Johnson immediately challenges the court's authority. He claims he doesn't understand the nature and cause of the accusation, questions jurisdiction, and refuses to cooperate, even after the judge clearly explains the charges multiple times. Every time Judge Webster tries to move the hearing forward, he interrupts. He objects. He argues. He insists the court has no power over him. The judge remains calm at first, patiently explaining the process and even entering a not guilty plea on his behalf, as the law allows. But Mr. Johnson won't stop. He keeps talking over her, refuses to follow instructions, and continues challenging the legitimacy of the proceedings. That's when things escalate. Judge Webster warns him about contempt of court, meaning he could face immediate jail time for disrupting the hearing. Still, he pushes back. The interruptions continue. The tension builds. And finally, after multiple warnings, the judge has had enough. Officers step in and escort Mr. Johnson out of the courtroom. Despite the chaos, the case moves forward. He's given a new court date and warned that failure to appear again will result in arrest. His $1,000 bond remains in place. What started as a basic traffic case turned into a powerful example of what happens when courtroom rules are ignored. In the end, the court's authority stands, and the consequences become very real.
Mr. Johnson, appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you can get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
you're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty, and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
Well, then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you time.
I object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering a plea
objection
on my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call
I'm
the state to the. I would like to call the state to the stand, Your Honor.
We're not doing that,
state bringing charges against me. Who's it? How did I injure the state?
all right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping. Missy?
Well, Your Honor, I would like to also bring to
September
according to USC 12203.
Deputy Miles.
And also Article 3, the judge must operate in good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again.
Deputy Miles, could you come in and assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right. So your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor, I also have a right to understand the nature of the cause.
If you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just
don't
want to
fill them
understand the
out,
nature
I'm
of
going,
calls.
if you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in, or have you been in, the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk up, either leave.
Your Honor, I'm trying to understand.
Or leave disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers, I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
All I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to do that.
If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is the charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal.
But according to the Constitution, there are only two jurisdictions.
All right, we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with. I'm not giving y'all a problem. I'm trying to.
What you are about to hear is how a routine traffic case slowly turned into a tense, drawn-out courtroom battle, not because of the charges themselves, but because of one man's refusal to recognize the authority of the court standing right in front of him. The hearing begins like any other. Mr. Johnson is called forward to address two charges. driving 82 miles per hour in a 65 mile per hour zone, and operating a vehicle without proof of insurance. On the surface, it's straightforward. The speeding charge is a traffic infraction. The insurance issue, however, carries more weight. It's classified as a misdemeanor, which means it isn't just a ticket, it carries a mandatory minimum fine and even the possibility of jail time. Nothing extraordinary, just the legal process moving as it normally does. But almost immediately, the tone shifts. When the judge asks Mr. Johnson to enter a plea, instead of answering, guilty, or not guilty, he begins questioning the very foundation of the proceeding. He says he does not understand the nature and cause of the accusation. The judge calmly explains it again, speeding 82 in a 65, and no proof of insurance. She outlines the potential penalties. She makes it clear that this is an arraignment, a procedural step where the charges are formally addressed and a plea is entered so the case can move forward. Still, he refuses. Instead of engaging with the explanation, he challenges jurisdiction. He questions whether the court has authority over him. He presses for clarification in a way that suggests he's not simply confused, he's rejecting the framework entirely. The judge attempts to keep things moving. She reiterates that this is a court of law with proper jurisdiction over traffic and misdemeanor offenses. She reminds him that he is required to respond to the charges. He continues interrupting. The judge maintains composure. She explains that if a defendant refuses to enter a plea, the court will enter a not guilty plea on their behalf. That's standard procedure. It protects the defendant's rights and allows the case to proceed toward trial or resolution. She makes it clear this is not optional. It is how the system functions. Mr. Johnson objects immediately. He insists she cannot enter a plea without his consent. He argues that he does not agree to the process. The judge explains again, patiently, deliberately, that the law permits her to enter a not guilty plea when a defendant refuses. It does not require his agreement. The exchange grows more tense. Every time the judge attempts to clarify or move forward, he interrupts. He talks over her. He circles back to jurisdiction. He insists he does not consent. The judge warns him that speaking out of turn and disrupting the hearing will not help his case. Courtroom procedure demands order. One person speaks at a time. The judge controls the proceeding. But the interruptions continue. At this point, the judge's tone shifts slightly. It's still controlled, but firmer. She warns Mr. Johnson about contempt of court. Contempt is not symbolic. It carries immediate consequences. Fines. Jail time. She tells him directly that continued disruption could result in him being taken into custody right then and there. There's a moment where it seems like he might pause. But instead of stepping back, he presses forward again. He challenges her authority once more. He objects to the plea being entered. He refuses to simply acknowledge the charges and allow the case to move forward in the normal course. The judge proceeds anyway. A not guilty plea is entered on his behalf. A future court date is set, September 27 at 9 a.m. She informs him clearly that failure to appear will result in a warrant for his arrest. There is no ambiguity. She states it plainly so the record reflects that he has been properly notified. It's revealed that this is not his first missed appearance. He previously failed to appear, which resulted in a bond being set. A $1,000 cash bond was posted. That bond remains in effect. The court is not starting from scratch here. This case already has history. Even as these details are being explained, Mr. Johnson continues to argue. He insists he does not accept the court's jurisdiction. He objects repeatedly to the court's actions. The judge gives him multiple warnings. Each warning becomes more direct than the last. The courtroom atmosphere tightens. There is a clear line between asserting legal rights and disrupting a judicial proceeding. The judge makes it clear that he is crossing that line. Finally, after repeated interruptions and ignored warnings, the judge makes a decisive move. She orders deputies to remove him from the courtroom so the proceedings can continue without further disruption. Officers approach. He is escorted out. And just like that, the argument ends, not because he conceded, but because the court enforced its authority. What's striking about this entire exchange is how ordinary the underlying charges are. Speeding. No proof of insurance. These are cases handled in courtrooms every single day across the country. Most are resolved quickly, a plea, a fine, maybe a scheduled trial. But when a defendant refuses to participate in the legal framework itself, the process becomes longer, more complicated, and more severe. The judge did not raise her voice unnecessarily. She explained the charges. She explained the procedure. She issued warnings before taking action. The removal wasn't immediate, it followed multiple opportunities for compliance. That progression matters. From a legal standpoint, entering a not guilty plea on behalf of a silent or uncooperative defendant is routine. It ensures due process continues. It prevents a case from stalling simply because someone refuses to answer. Courts operate on structure. Without that structure, proceedings would collapse into chaos. Mr. Johnson's strategy, repeatedly questioning jurisdiction without presenting a recognized legal basis, did not stop the case. It did not dismiss the charges. It did not halt the court's authority. Instead, it escalated the situation to the point where he lost the ability to remain in the room. The consequences are now clear. A set court date. A continued $1,000 bond. A direct warning that failure to appear will result in arrest. And a courtroom record that reflects disruptive behavior and judicial warnings about contempt. What began as a traffic matter evolved into a demonstration of how the judicial system responds when challenged in this way. The law provides room for defense, for argument, for trial. But it does not allow a defendant to override the court's authority through refusal alone. In the end, the hearing serves as a reminder. Courtrooms are governed by procedure, not personal belief. Participation may be uncomfortable. It may be frustrating. But ignoring the framework does not make it disappear. It only narrows the space in which someone can effectively defend themselves. And now, the next chapter of this case will unfold on the date the judge set, with or without cooperation.